Welcome to Employment Law This Week. I'm George Whipple. Our top story, President Trump nominates Judge Brett Kavanaugh to the Supreme Court. Trump named his pick last week for the seat vacated by Justice Anthony Kennedy's retirement. Judge Kavanaugh was appointed to the D.C. Circuit in 2006 by President George W. Bush. Senate hearings are likely to be contentious with such a slim GOP majority. So the administration is touting Kavanaugh's anti-regulation record and business-friendly rulings in order to smooth the path to confirmation. While he clerked for Justice Kennedy, many see Kavanaugh's judicial philosophy as more similar to the late Justice Scalia. Jim Flynn has more.
Management and employers will, I think, have a friend in Judge Kavanaugh on the bench. It's reflected in several of his opinions while he was on the Court of Appeals. You can see that in cases like Adeyemi, where he said that courts shouldn't be super personnel departments. You see it in that same case where he says they shouldn't micromanage what employers do. You see it in many other cases where he says businesses need to do what businesses do, and we need to just make sure they stay within the law. Employees will actually be pleasantly surprised by Judge Kavanaugh as well. He's shown in several of his decisions a real fire to suppress discrimination. It can be seen in the Ayissi-Etoh case, where he said that one single use of the N-word in and of itself could establish a hostile work environment. He went out of his way to describe the history of the offensiveness of that word. Similarly, in the Ortiz-Diaz case, he actually prompted the D.C. Circuit to reverse itself and find that lateral transfers, if racially motivated, could violate Title VII.
New Jersey tees up employment legislation. Several bills pending in New Jersey will significantly impact employers if they're passed. New Jersey Governor Murphy, sworn in January 16th, has already signed a pay equity law and legislation mandating paid sick leave. Now the state Senate has approved bills that ban salary history questions, limit access to employee credit reports, and prohibit non-disclosure agreements relating to discrimination or harassment claims. These bills await further action by the state assembly and the governor. A California court finds a hospital policy of rounding hours is legal. A California appeals court has found that a Los Angeles hospital's policy of rounding employees' hours does not violate the state's wage and hour laws. The hospital system automatically rounds workers' hours up or down to the nearest quarter hour. The court found that the policy is legal because there was no evidence that it had resulted in a systematic loss of wages. And still more states are taking action in the face of stalled federal employment policies. The Pennsylvania Department of Labor has proposed regulations that would increase the overtime salary threshold significantly. The changes would bring Pennsylvania law in line with the 2016 proposed FLSA regulations, which were blocked before they took effect. Massachusetts recently enacted the Grand Bargain, compromise legislation that increases the minimum wage to $15 an hour, creates a sales tax holiday, phases out Sunday and holiday premium pay requirements, and introduces new paid family and medical leave provisions. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.